Hey everyone, we're back for week, what are we now, 15? So this is the week starting April 20th. As you can see here, we're going to be doing Southern Pacific Co., Pike, South Central Timber, Maine, Camps, Newfound, Owatonna, and Comptroller of Treasury versus Maryland. That's going to be a continuation of our Dormant Commerce Clause cases. In case you forgot, just to freshen you up, hang on, get this cord, there we go, to remind you, the Dormant Commerce Clause is the implication that if, since Congress is granted an affirmative power, that it must mean that that is a removal of power from the states. This is why it's also called the Negative Commerce Clause. So a granting of power must mean the removal of power from somewhere else, and therefore the states lose this ability. Interstate commerce, I should say. So yeah, we'll do those, and then we'll get to Dartmouth, Charles River Bridge, and those are going to be the beginning of our, we don't have many, but a handful of contract clause cases, which is Article 1, Section 8, I forget the clause number. I think it's 10 maybe. But yeah. Okay, so let's start with Southern Pacific Co. So in this case, it dealt with a problem, and that is way back in the day, so we're talking in the 40s, even going back further to the 1800s, is the court is struggling in the aftermath of Cooley, just to go back one slide from last week. How do we handle this balancing test that was proposed in Cooley versus what is it, Board of Wardens, I think it is? Yeah, Board of Wardens. So remember this implication slide talked about, well, how do we approach this localized interest but interstate effect, right? And so what comes out of this then is they started coming, the first attempt is the Southern Pacific Company approach, and that is, let's come up with a balancing test to claim by the states that they should receive deference regarding local safety concerns. And so the argument was, look, we have all sorts of local safety concerns. Think about things like quarantine, very pertinent, right? Think about regulation of things that don't involve interstate marketplaces, policing, stuff like that. So this case is going to represent this case-by-case approach by the court for a long period of how they're going to handle Dormant Commerce Clause cases. And they would determine if a state regulation was a burden on interstate commerce or if it wasn't, and they could go forward. For example, in 1931, in a case called Missouri Pacific Company versus Norwood, the court upheld a law requiring full crews on trains, while here, in this Southern Pacific Company case, it's going to strike down another similar safety claim. So why the difference, right? What they're going to say is that, well, in that instance, the full crew law had in the opinion of the court, it had a demonstrable safety benefit that didn't significantly burden interstate commerce. And they said, moreover, this line of reasoning also extended to regulation of things like highways, right? And so you can think about, for example, you ever notice, they don't really have many in Texas. I think I've seen them, but they're never really in use. But those like weigh stations, the weight stations, so like you have trucks and they get weighed, right? So why do they have those? Well, part of the reason is the state's interested in, going from one weight station to another. Is the weight the same? Because if it's not, significantly, you can tell they're probably smuggling something illegal. Or it could also be the damage to the roads, right? Overly weighted things deals more damage, right? So you could say, well, those sort of those things are still around, right? These things that might have an impact on interstate commerce, but the states have legitimate safety concern. Another example is South Carolina Highway Department versus Barnwell Brothers Incorporated in 1938, where the court sustained a weight and width limitation on trucks operating on state roads, but it had struck down other regulations. So there's this is how they're going to approach it for a period of time, and that is, we'll take it case by case. We'll look at what the restriction is by the state. Is it overly burdensome on interstate commerce? So here the burden is, we, Arizona, are going to limit passenger train cars to 14 freight trains and freight trains to 70 cars. So the reason why they claim this, and this is an important distinction that if you read carefully, you'll know, slack action. This refers to a whiplash effect. So whenever you have a really long train, even though it's not going that fast, when it goes around a curve, it creates sort of like a cracking, right? So imagine the cracking of a whip, right? So really long trains created this slack action that occurred. And so they wanted to limit this effect on freight and passenger trains. So the way that they did this is you'd simply have less trains running, right? So the question is this a violation of interstate commerce? And here they're going to say, yeah, it is. That the regulatory burden proposed by Arizona doesn't outweigh the burden that's imposed on interstate commerce, and that's only something Congress can do. So let's look at Justice Stone's majority opinion. He starts by saying that the court says, in this first point here, that we're going to assume that Congress has interstate commerce ability, obviously, right? But that doesn't mean that in the face of congressional silence, states can do nothing, right? He says, quote, in the absence of conflicting legislation of Congress, that there resides power in the states to make local laws, even if those laws affect interstate commerce, or even if they regulate it. But This has largely been restricted in instances where Congress has failed to act, meaning that it's not carte blanche, they can do whatever they want. And he says, going back all the way to Gibbons-Ogden, the ruling there, it has been made clear that the states may not impede the flow of interstate commerce. So that then becomes the question of, well, can they do this? Is this overly burdensome, right? They say on matters of national standards, only Congress can prescribe the standards, and that if the courts were to permit one state to make regulations, it would have the effect of altering the behavior of all other states, because these trains aren't just going within Arizona, they're going out of the state of Arizona. So now you're forcing people coming into Arizona, like let's say you're coming from Texas, you want to go into Arizona, you now have to limit the size of your trains, right, to 14 for passenger, 70 for freight. You're now facing the burden that Arizona has imposed upon you, and only Congress can do that. And only Congress can determine the best operation of the national railway system. So here, they look at this claim. Well, what about the claim by Arizona? Safety, right? Because they've allowed, as I mentioned in those just before when we started the slide, or the last slide, they have sustained certain regulations for safety concerns. Here they said, though, Arizona says, look, 93% of freight, 95% of passenger traffic is interstate, right? So if we buy your argument and we put a cap on the number of cars, it means we have to run more trains to make up the same amount of cargo and people. So in reality, more trains, as just with more cars on roadways or railways, means more accidents. The very safety concern you're claiming to prevent slack action is undermined by the fact that you have to run more trains to make up for the fact that your train cars, the number of cars strung together, train line, I guess, whatever, I don't know what the term is now, you have to have more of them, right? More trains, more accidents. So you're undermining the very goal you're attempting to claim, the court says. They also said that the reduction in the length of trains tends to increase the number of accidents because of the increase of the number of trains, as I just said. And it also increases congestion, right? And then finally, this seems to, given that we've sort of destroyed your safety concern, it's supposed to be a period. Destroyed your safety concern, your justification essentially falls away. Not only does the state law fail to provide proof safety, they say it may be worse. The law affects both efficiency and economy, and economy and efficient rail service in the nation is a national interest and must prevail. Let's go to our dissents. Justice Hugo Black on the safety concern. He says, I buy it. I buy the safety concern. He says, this takes up point number 2 on the last slide. He says that the idea that there is no legitimate safety claim here is not realistic. Evidence, he says, shows that the slack action caused by long trains means injuries at the ends of those trains. You have a legitimate safety concern. So he says, what about the harm on the lack of uniformity? He says, well, the harm of these claims, these are all basically the same claim, that economic cost is going to be a problem, right? Delay of interstate commerce, impair efficiency. But really all you're talking about with all these increased costs, all these different claims are the same thing, and that is economics. We're not economists, nor should we be concerned with the economy. We're concerned with the Constitution. And this is not, in his mind, an excess of constitutional power, a constitutional authority by the states. Okay, let's move to the modern era. So in Pike, they're going to adopt a balancing test as opposed to the sort of case by case. And this is probably for the best because it causes confusion in the lower courts. How should we approach, this case that's before us now? It also creates a problem because it means that you can have sort of weird decisions where, like, okay, that's a legitimate safety concern, but that one's not. Well, what's the difference? We said so. And so it's really the judges using their own opinions to determine the necessity of something, and that's really not what judges should be doing, right? Oh, so hang on a second. There we go. So Pike. So this case deals with cantaloupes. A lot of these cases deal with agriculture. I guess it's because states have weird regulations on. They always want to tout their agriculture as like, we have the best. These are the best apples and potatoes. Think about we think of Idaho, we think about Florida oranges. These sort of stereotypical crops. The states really want to tout theirs as the best, right? So as it says here, the respondent Bruce Church grows cantaloupes in Arizona. And the produce here is inspected and packaged in California. Not that uncommon, I guess, right? And so the state of Arizona requires, as it says here, all fruits and vegetables shipped outside the state must be packaged in accordance with Arizona law. So think about what you're doing. You're requiring states, conditions for how these things are shipped. However, this means, as it says here, that requiring them to have it packaged in Arizona is going to cost them money, a huge chunk of money. And they would incur the cost for this because instead of packaging them in another state, they forced to package them in state, right? So the question here is this a violation? is this Arizona law, the Fruit and Vegetable Standardization Act. Is it a violation of the Dormant Commerce Clause? Remember, when we talk about Dormant Commerce Clause or Negative Commerce Clause, which is the same thing, we're always talking actually about the Commerce Clause, Article 1, Section 8, Clause 3. Because remember, we're talking about the grant of power must mean the denial of power. So if you're looking for the words dormant or negative in the Constitution, you're not going to find it. You're just going to find Commerce Clause. So this was, if you're in the moot court, this week I think, it can be a little bit confusing, is if you're looking for Dormant Commerce Clause cases, you often you can't just search like Justia or oh yeah. You have to maybe oh yeah you could, but you often would have to look for like an internet search for cases, and then you would specifying the Dormant Commerce Clause, and then you could find it based on that, right? So here they say the law is unconstitutional. Let's see why. This was not really surprising, probably. So beginning with the first claim. So Pike says that the law is Pike representing the state of Arizona, is no burden on interstate commerce because it regulates, as it says here, intrastate packaging of the goods. This claim sounds a little bit familiar, doesn't it? It sounds sort of like Hammer versus Degenhardt, where, remember there, that dealt with child labor laws, and they said that, look, child labor in itself is not an interstate commercial activity. It's only when those goods are put on the marketplace, right? But of course, the court, initially is accepting of this, but now they would say, no, of course not. It's still an interstate. It's involved in interstate commerce, right? The goods are meant for interstate transactions. Nobody's making them just to sell it within the state, right? Here, the court also says, noting the date, right? This is way after the Hammer versus Degenhardt case. Said no, that doesn't work. They say that there's, the claim that there's no violation because articles being made ready for interstate movement are not necessarily in interstate commerce is just sort of laughable, right? Because what the concern should be is if there's an effect. Think about remember the good test question. Remember the three Commerce Clause conditions, right? We have the channels of commerce, the instrumentalities of commerce, meaning the things that actually move across, so like boats, trucks, people in some cases, and the anything that substantially affects commerce, right? This sounds more like that third one. You're still having a substantial effect on interstate commercial marketplaces, even though the packaging is occurring within the state, right? So they say the question becomes this. Given that there is a burden, so clearly it does affect the interstate commerce. That doesn't necessarily mean it's struck down, though, right? Remember, there is still some room for the states to use their authority. So how should we approach instances where the states are burdening interstate commerce when we should allow those as not a substantial burden versus not? So they come up with a test, and it's called Pike balancing. So let's take a look at what it says. This is the language from the case. The court will tolerate the burden on interstate commerce if the effects on interstate commerce the effects on interstate commerce that are only incidental, so limited, right, to that incident, unless the burden imposed on such commerce is clearly excessive in relation to punitive local benefits. If a legitimate local purpose is found, the question becomes one of degree. So, in other words, and they go on to say that the extent of the burden that will be tolerated will, of course, depend on the nature of the local interest involved and on whether it could be promoted as well with less impact on interstate activities. So could you have done this another way? So basically they're saying, is there a local concern? Is it an incidental limited burden on interstate marketplaces? If so, then it becomes a question of degree. And here's what they'll do when that happens. There we go. So let's take that idea then of, okay, so what is it? Is it an incidental burden? If not, it's going to be, per se, rule of invalidity. You can't do it. If it is only an incidental burden, then they'll engage in this balancing, right? They'll say, okay, well, incidental burden, it's going to become one of degree. We'll have to look at the localized interest involved and then the impact on interstate commerce, and we'll see if it's sort of excessive. Now, I know you're thinking that's kind of a squishy test, but it's all they had, right? It's better than nothing. So here, let's take a look at this Arizona law. Here, the law wanted to protect and enhance the reputation of Arizona. What are these, cantaloupes, right? Cantaloupe growers? Yeah. And the court said, look, that's a legitimate goal, right? You want to promote your produce. Perfectly fine. All states want to do this, right? The question, though, is, okay, what about, now that application within the state is obviously fine, right? Perfectly okay. The problem is when you're talking about the application out of state. So the application of the law, they say, quote, has a far different impact and quite different purpose. Here, Arizona's interest in wanting its produce to carry recognition of the state in which it was grown cannot constitutionally justify this requirement that they be packaged in state and not out of state. They say that now, does that mean that you could never have come up with some sort of scheme that promotes in-state packagers? No, right? They leave the door open, and they say that they could envision an instance where there was a more compelling state interest, where the state law might be tolerated, that leads to this sort of discrimination on interstate commerce, right, for favoritism. But here they say the state interest is really minimal. Promotion of your produce is not sufficient enough to tolerate this burden. Okay. Let me see here if we want to. No, okay. I was debating if I wanted to go over a case that I used to cover in this class, but we'll skip it for time. All right, let's go to South Central Timber Development Incorporated versus Wunnicke. This is just an example case of this is to give us. If you go back to that flow chart I showed you in the last class, this is an example of one of the exceptions. So could there be an exception to the Dormant Commerce Clause? We already established Pike balancing. It's possible that the state could have a compelling interest that allows it to discriminate on interstate commerce, but that's how you determine if it does. Is there an instance where you would, and if they fail, then you say per se rule of invalidity, you cannot have it, right? Per se, totally invalid. Is there an exception to this where we don't have to go down either of those roads, Pike balancing or per se rule of invalidity? They're going to say yeah. They actually established this idea of a exception in 1976 in a case called Hughes versus Alexandria Scrap. The reason why we're not reading that case is because in Hughes versus Alexandria Scrap, it's what's called the market participant exception, is that in that instance the court sort of created the idea that there could be a market participant exception, but they failed to actually grant it. This is, to my knowledge, I believe this is the first case where they actually the state successfully claimed to be a market participant and were granted the exception. So before we go into this, and I'll give you a little more background. Well, actually, let me give you a little background, and we'll go, and then I think it'll fill it out. So a lot of textbooks will cite that Hughes versus Alexandria Scrap is sort of the case that establishes this idea as market participant exception, but really it wasn't until 4 years later in a case called Reeves versus Stake the court actually granted the market participant exception in the positive sense. Actually, did it. In that case, in the Reeves versus Stake case, it dealt with South Dakota was operating a cement plant, and a substantial percentage of the plant's production was sold to buyers outside of the state, which would make sense. And one of those was Reeves Incorporated, one of the buyers. And they were a concrete distributor in Wyoming, and they got 90% of its cement from that state-run plant in South Dakota. And in 1978, for economic reasons, the South Dakota plant began supplying in-state customers before honoring other commitments. And so Reeves challenged the South Dakota process, I guess it was a law, is essentially hoarding of the state resources, right? So the question there was, did South Dakota's preferential system saying you have to give to in-state users before you sell out of state, is that a violation of the Commerce Clause? With there, the court reaffirmed its holding and establishing this idea that, this is a quote from the case, nothing in the purposes animating the Commerce Clause prohibits a state, in the absence of congressional action, from participating in the market and exercising its right to favor its own citizens over others. In other words, you can act as a market participant, and it's not a violation of the Commerce Clause. So then why are we taking up this case instead of one of those? Why not take up Hughes, which establishes it, or Reeves, which is an example of them actually, because remember in Hughes they didn't actually grant the exception. In Reeves they did. Why take up this one? This one is because this is the modern standard asking if the state is a regulator or participator, and it gives us a clear definition of at what point are you a market participant, and at which point can you not be a market participant because you're also acting as the state in terms of regulation of the marketplace, right? Good example of market participant exception. We mentioned this way back when we were still in class. Somebody asked about in-state versus out-of-state tuition. Why can you do that and not be some sort of, discrimination or something like that, or a Commerce Clause violation? Because the state, via its schools, right? Now, if you're a private school, it doesn't matter. You can discriminate on whatever the hell you want, right? You can treat in-state, out-of-state differently for whatever reason. But why can the state do it? Because they're a market participant. They're selling education, and if they want to prefer certain customers, they can. Think about, like, for example, what if you have really good credit and you want to get a credit card, and versus like your neighbor, and they have really bad credit, and they offer you like a 10% annual interest rate APR, and then the other person's like 20%, right? Well, why? They're favoring you because of your credit score. Companies can choose to do that. The state, acting like a business, can also choose to do that, including choosing to favor its own citizens, right? So the question becomes, when are they acting like a market participant versus when are they acting like a regulator? That's what South Central Timber is going to tell us. So look at the plan. Alaska creates this legal provision. all Alaskan timber must be partially processed before it was shipped out of state. South Central says, no, you're violating Commerce Clause provisions. Were they a market participant? They also make a couple other claims too. Here they say there is a market participant exception. We do reaffirm Hughes and Reeves. You, however, Alaska, were not acting like a market participant in this case. You were acting like a regulator. So what's the difference? Let's go through. So Justice White begins by citing 3 cases and saying, here's the history of market participant exceptions. And here they are. Here are 3. I mentioned 2 of them already. Hughes versus Alexandria Scrap and Reeves versus Stake. In Hughes, they established a market participant exception in 1976. As it says here, it was a Maryland program to reduce junked cars with greater requirements for out-of-state cars. And the court rejected Commerce Clause challenges there because of the absence of congressional action. So again, this is in the face of congressional silence, the states are making these policies. Congress still could act, right? So like, what if Congress makes a law and says that in-state versus out-of-state tuition must be the same for all students, and they make a Commerce Clause claim? Presumably, they could do that. They simply allow the states to continue. So they've been silent on it, really on all matters of education, higher education anyway, right? Well, most matters of higher education and pretty much all matters of primary, secondary. Secondly, the Reeves case, mentioned that already. There they said the Commerce Clause places no restrictions on the state's refusal to deal with particular parties when it's participating in interstate market goods. And then finally, in White versus Massachusetts, as it says here, this was a Boston city law or ordinance, I guess, requiring all construction funded by the city to use at least 50% of Bostonians' projects. And there they said, well, there's some limits on the state and local restrictions, so since a city is part of a state, that the court didn't define what the limits are. Essentially here, everyone was working for a city, and in regard, that city is acting like a participant, right? So let's look at these 3 and think about this case and see why it fails. So the court takes them case by case, right? This is point number 2. They start with Hughes versus Hughes versus Alexandria Scrap, which I think on the last slide I actually made a mistake and said that they did not uphold it. They did uphold market participant exception there. So Maryland, they said in that case, became a purchaser of scrap, right? Here, however, Alaska participates in the timber marketplace, but it also imposes conditions downstream. It's not merely subsidizing local timber, it's also participating in regulation of the marketplace itself. Looking at Reeves versus Stake, they said that Alaska, unlike Reeves versus Stake, that Alaska says the application of Reeves put no limits on the terms to which it may sell its timber, but the court disagrees. They say that, quote, Reeves did not purport to sanction the imposition of any terms the state might desire. Also, there was no foreign commerce in Reeves. There is here. South Central Timber is selling their timber to Japan. So you have not only interstate but international commerce. And then finally in White, the state here is more, they say, than just a mere seller of timber. Here, even if someone buys the timber, he can't do anything with it that he pleases. Alaska, they say, first has to process it under this law. And so they say, quote, while the market participant doctrine permits the state to influence a discrete identifiable class of economic activity in which it is a major participant, it is not carte blanche to impose any conditions that the state has the economic power to dictate. In other words, you can't be both regulator and seller at the same time, right? Finally, the last point here there's 2 more points. The third point, so then where is the limit, right? And this, they tell us the limit of the market participant exception doctrine. So this is the bounds, right? When can a state act like a market participant versus at what point have they also acted as a regulator, which they can't do? They say that the limits of the market participant exception doctrine must be that it allows the state to impose burdens on interstate commerce within the market in which it is a participant, but allows it to go no further. So you can impose the burdens, but you can't control it, right? They say that the market must be narrowly defined. So what's the definition of the market? In this case, South Central argues that although Alaska is participating, it's using its, quote, leverage in the market to exert a regulator effect on the processing market. That is not participation. And the court says, we agree. That has moved outside the bounds of simple participation and into regulation. The last point from Justice White, he says, so where are the bounds of this exception? Where did Alaska go wrong, right? Sort of reiterating the point that we just mentioned. Firstly, as it says here, a state market participant is only interested in the transaction. Once I've sold you the goods, you can do whatever the hell you want with them. Quote, we reject the contention that a state's action as a market regulator may be upheld against a Commerce Clause challenge on the grounds that the state could achieve the same end as a market participant. That is not enough. Also, they say a state can't claim the exception and then impose a downstream regulatory effect. Here, Alaska is attempting to govern the private, separate economic relationships of its trading partners. They say a state can't claim to be a market participant to act as a front to regulate downstream timber market processing, right? Once you sell the goods, that's it. You can't do anything with it later. Finally, it's not enough Alaska doesn't substantially burden the commerce, because that would still then, even if that were the case, which it's not, you would trigger Pike balancing, which you'd probably fail. They say that the state argues that what the state tries to say is, look, even if we can't win with the market participant exception, we've got a second argument. And that is, look, even if the main arguments fail here, one, that Congress did implicitly authorize the restrictions, and two, that there's a market participant exception. Those are their sort of two main claims. The state claims that and the court says no to both of those. The state claims that the restriction doesn't burden interstate foreign commerce, but the court says no, because even if we bought that argument, which we don't, you'd still have to turn to Pike balancing, and if we did that, we would, even if we applied that, you would still fall under the is there a substantial burden? The answer would be yes, and then it's invalid per se rule of invalidity, right? So that doesn't work. The Court of Appeals below found that Congress, remember I mentioned just a second ago, that the first argument, that implicit authorization from Congress, so Congress didn't actually say they could do this, so where are they getting the idea that they should? This comes from the lower court. The Court of Appeals found that Congress, they argue that they implicitly authorized the timber processing policy for the timber taken from Alaskan lands. Actually, though, the policy applied to federal lands and not state lands. So the idea is that, look, Congress has agreed to this, but no, they didn't. They had different regulations for their land, the federal land, but not yours, right? All right, last bit is Rehnquist's dissent. He says, how is this any different from White versus Massachusetts? He says the burden of, there they burden resident hiring, right, Bostonians. Alaska, he says, quote, is merely paying the buyer of the timber indirectly by means of a reduced price to hire Alaskan residents to process the timber. So if there's no burden, then there's no problem, right? So essentially, it seems like he's sort of arguing that, well, this market participant exception thing's a little too squishy, and then even if we look, and then once we look at the facts, he still probably could have got under via, if we went down the Pike balancing road, he still could have saved this thing, right? All right, let's turn to, get rid of that one, Maine versus Taylor. So we're in 1986. Let's recap what the court has established so far. If there's a burden on interstate commerce caused by a state, Congress has not acted. Congressional silence. How do we deal with this? Like, when is this state burdening interstate commerce, or international? But that by definition would be interstate. When it's burdening interstate commerce, at what point is it invalid, right? And are there any exceptions? So far we've said that if the burden is incidental, right? Then we'll engage in Pike balancing. We'll determine, and we can go back to Pike versus Bruce Church. If the burden is substantial, the law is the state program is immediately struck down under the per se rule of invalidity, right? Virtually per se rule of invalidity, meaning almost always virtually per se, by definition, it will be invalid, right? You're basically just going right against what the Constitution says, so it's just per se invalid. Is there an exception? So far we said yes. If the state's acting like a market participant, they can still treat interstate commerce differently, right? So we've carved out this sort of three-path analysis. The question that's going to be raised here in Maine is, could there ever be a possibility an exception to the per se rule of invalidity? So we just said that there's only three paths. Could you ever go down that road of the state actually engaging in discrimination against interstate commerce, but it still is justified? Maine versus Taylor is going to give us that. So let's look at the background. You got Robert Taylor, he's bait fish, he's going to get imported into Maine, but there's a federal law that makes it a crime to violate this, and we'll explain why. I'll explain why in a second, but so he wants to move to dismiss. He says, look, this is a violation of the Commerce Clause, you're discriminating on interstate commerce, this, Maine is. Sorry, I was looking at where it is in the slide there. So it's this federal law making it a federal crime to import fish in violation of state law. So it's also, so Maine's trying to say, we don't want you bringing in these bait fish. Is it a violation? They're surprisingly going to say no, right? This is where they're going to carve out that exception. When there is a legitimate local purpose that could not be served by some other non-discriminatory means, it is possible the state will get an exception to the per se rule of invalidity. So in this, so what's happening here is this federal law that barred the importation in violation of state law bit had to deal with the importation, in this case, of 158,000 of these bait fish, these golden shiners. And this was intercepted by the feds, and the grand jury in the district court for Maine indicted them for violation of this law. And so the question then is, well, why might you ever need this exception, right? Listen to this quote. We'll go into more detail in the next slide. This quote's from the big leather-bound con law book that is in the library by I forget who the authors are. It doesn't matter. Anyway, so listen to what they have in their analysis. So they said, in determining if a state overstepped its role in regulating interstate commerce, the court has distinguished incidental burdens, right? So small incidental, in this instance, incidental burdens from those that are clearly excessive to benefit local interests. For example, Pike, right? That's what the Pike. If it's not, then they would engage in Pike balancing. For those that are excessive, the court turns to Hughes versus Oklahoma for a more demanding scrutiny, right? So we're talking about per se rule of invalidity stuff. The burden then falls on the state to show that the purpose couldn't be served by other non-discriminatory means. And they cite a case called Hunt, which dealt with apple growers and the discrimination of and their certification of stickers on apples. Doesn't really matter. So what the idea here is that there could be an exception, and it's going to be carved out when the state has no alternative but to protect a legitimate state interest via discriminatory means, discrimination against interstate commercial sources. So let's start with the analysis by Blackman. So he says the court here has determined that the Commerce Clause limits the ability of states to erect barriers. Makes sense. We've also distinguished that state laws that are incidentally burdening to interstate commerce could survive versus those that are facially discriminatory. He's making the distinction between Pike balancing and virtually per se rule of invalidity. Facially discriminatory versus small incidentals, right? So he says, what we did to determine this, he says, statutes in that second category, facial discrimination, he says, require demanding scrutiny, meaning the bar is really high. The burden falls on the state. Think about strict scrutiny analysis for equal protection clause, something like that. In this instance, the burden will shift to the state, and the state must satisfy this. This two-part test is called the Hughes Test sometimes, and it comes from Hughes versus Oklahoma, 1979. Hughes versus Oklahoma was actually a very similar case to this one. In fact, they're nearly identical. The only difference is, and the reason why we're not taking up the Hughes case, is because in Hughes, the court there held that Congress can enact legislation to govern wildlife on federal lands, and when it comes into conflict with state laws, the supremacy clause means that the federal law will prevail. So in that instance, the court points out there could be a compelling interest for the states to engage in discrimination in the face of congressional silence. Here, though, there is a clear instance of Congress regulating the interstate marketplace. In that case, by the way, just to give you a little background in the Hughes case, Oklahoma had a law that prevented any person from selling minnows found in the natural waters of the state of Oklahoma outside of Oklahoma. And so they claimed that the purpose of the statute was wildlife conservation, right? And so what the court points out, though, even though this is it's a very similar case, where we're talking about bait fish in both of these, that they point out, in Hughes, they pointed out that there could be an exception, right? There could be a possibility that the per se rule of invalidity doesn't apply, but it didn't apply in that case. Here, Maine versus Taylor, we see the first instance of a successful application of that exception. So they say what Hughes also established was sort of a two-part test, right? The Hughes test, if you will. And they said that if it's incidental, Pike balancing, right? If it's facially discriminatory, virtually per se rule of invalidity, the law will be struck down. But perhaps there could be an exception, right, when it could not be achieved through non-discriminatory means. So here's what Maine claims is why we need this. Parasites. The threat parasites pose from out-of-state fish to the Maine population of fish. Maine has several claims to justify the policy, and this is directly from your readings. One, Maine said that state wild fish populations would be at risk because of parasites prevalent in out-of-state fish. Two, non-native species inadvertently included in the shipments of live bait fish could disturb Maine's ecology, because this is 158,000 friggin' fish. Some of those aren't going to be golden shiners. Some of them are just going to be swept up in there, right? And it's also, they say, look, because of these first 2 points, this invasive species and the parasites thing, Maine claims that there's really no satisfactory way to inspect the shipments. There's no way it's physically impossible to inspect all 158,000 fish to make sure that they're golden shiners and that they don't have parasites. So given that there is no alternative, we need to have the ban. The court says, you're right. Quote, we agree with the district court that Maine has a legitimate interest in guarding against imperfectly understood environmental risks, despite the possibility that they may ultimately prove to be negligible. Meaning, though, even though it's not, might not be that big of a threat, Maine can still guard itself. The question here is, well, this opens the door to what about hypothetical risks? So could I say, well, I don't know about the possible impact, but it could be this, right? It's purely speculative. It seems like the court's willing to entertain some of those, right? The final point here is that the Commerce Clause limits the ability of the states, but it doesn't mean that you have to take in every sort of trade at the expense of your own citizens. Quote, while the Commerce Clause limits the power of states, that free trade can't trump all other values. And they say that as long as the state isn't needlessly interfering with interstate commerce, that it retains broad regulatory authority to protect the health and safety of its citizens and its natural resources. Here they say there is a legitimate local purpose and there is no other alternative non-discriminatory means to achieve it. So that's the exception. You have to show that there is a legitimate local purpose. The burden shifts to the states, right? If you're facially discriminating on interstate commerce without in the face of congressional silence. So basically, the state is definitely violating the Dormant Commerce Clause. They can still get away with it if the two conditions: legitimate local purpose and no other non-discriminatory alternative exists. They have to do this to achieve that legitimate purpose. There can be the exception. Okay, so we've carved it out, right? Let's turn to Stevens' dissent. He says that definitely should start with Hughes, but from there we go awry. He sees the fact that there are already golden shiners grown and harvested in Maine, and that the ban of out-of-state fish is just a blatant violation. And he reaches this conclusion by using the same test, Hughes. He just applies it. When he applies it, he sees a different outcome. What Stevens says in this first bit here, in point number 2, look, I conclude that the state has no obligation to develop feasible inspection procedures. Got it. But that doesn't mean that they should be given a free pass, right? He means that since the state engages in obvious discrimination against out-of-state commerce, that the burden has to shift to the state. Seems like the majority would agree with that. To prove that there is truly no way to test these fish. Therefore, they need a total ban. What he says, though, is that I do agree that the burden should shift to the state, and that's where they failed. They have failed to show that there actually is no legitimate way. They haven't even attempted to engage in the inspections. They simply said, we assume it's not humanly possible, right? He says that if a state can defend an ordinance because of a health measure, then the Commerce Clause imposes no constraints, quote, other than those laid down by due process. Or if a state admits to making the law to discriminate against interstate commerce. You've essentially opened the doors to all sorts of discrimination as long as they make some sort of health claim, right? This is especially pertinent now. Think about states. What if, like, for example, this would be sort of interesting. What if the state of Texas said, it could be something minor, like anyone or any person operating a motor vehicle, whatever, flying in, whatever, coming from the state of New York, where there's a known sort of hotspot, or maybe New York City, right? What if we said they had to get temperature checks? Probably wouldn't seem unreasonable. I doubt you'd see many lawsuits out of that. What if they said you may not come in at all? People from the state of New York may not come in, right? Could you justify that? Or like, what if we said no goods? Let's keep it in the commercial aspect. No goods could be shipped from New York City. Could you justify that under a COVID-19, protection measure via the Dormant Commerce Clause? It's unclear. Maybe, right? It'd be kind of a stretch, and I doubt they would win it because it wouldn't really satisfy the condition that there is no other non-discriminatory alternative. There clearly is. You simply have them sterilize it, once it arrives. But you could see how the states could open this door to these exceptions. And the ecological thing. And then finally he says the third point here, the Court of Appeals, which is much more familiar with Maine's resources because they're located in Maine, that the burden of proof to meet this environmental concerns is sort of another matter, and they didn't really provide enough evidence to justify it. Okay, let's go to Camps, Newfound, Owatonna versus town of Harrison. Typically, this is just, since it's such a long name, it's typically just called Camps, Newfound. For short, which is what I'm going to call it. Okay, so this case is going to take up the issue of whether or not the state can affect a discriminatory impact via taxation. So here, normally when we're talking about interstate commerce, discrimination by the states, it's usually a policy that's like giving favoritism, or I shouldn't put that. It's a regulation. So think about like trains, produce, stuff like that. They're putting a burden on out-of-state sellers, right? Here the question is, can a state also violate the Dormant Commerce Clause when they give favoritism towards in-state sellers versus out-of-state sellers via taxation? And the answer is going to be, yeah, that can also be a violation. So here, as it says, Maine has this law. Businesses can receive exemptions from estate tax and personal property taxes. Estate taxes are the amount that you pay on inheritance, right? So like when somebody gets property. So like in the U.S. there's a federal estate tax. It's pretty. You have to make a lot of money to qualify for it. It's referred to sometimes as the death tax, right? So how much you pay on your estate once you die. Yeah, and then also personal property, so the property that you own, right? If they existed, as it says here, to benefit the residents of Maine, so like charitable organizations. But as it says here, this did not apply for those that primarily served non-Maine residents, and camps Newfound and Owatonna was one of those things. Most of the people that went to this camp were out of state or out of country because they're near the border with Canada. So, did they violate the Dormant Commerce Clause? Yes, right. They did so because they are treating they're sort of punishing people for engaging in interstate commerce via taxation, in this case, tax breaks. And therefore, that is a violation. So let's see how they get there. So prior to the adoption of this Constitution, and the related court rulings that came after it, there was a web of conflicting commercial regulations, and the court would say that this was part of the reason for the Constitution. This was destructive to the harmony of the states, right? So the town of Harrison is going to make a bunch of arguments, and they're all going to fall. So let's go through them all and see how they get there. Firstly, what about the legality of real estate taxes that treats nonprofits differently? Should there be an exception because it's simply a nonprofit? The town of Harrison argues that the Dormant Commerce Clause jurisprudence does not apply here because interstate commerce isn't an issue here. They say that Congress can't tax real estate, so it never was in their power to regulate it anyway. Specifically, they try to claim that the campers aren't articles of commerce, or because the camp's product is delivered and consumed entirely in the state of Maine, right, because it's not crossing state borders, it's just the camp, that there is no actual interstate commercial activity at all, right? So the court then, so that's their first bit, right? Does this avoid the Dormant Commerce Clause entirely? No, they say. They say this clearly is commerce. Think about, as we'll say here, Heart of Atlanta, right? The instrumentalities, right? Those people are actually engaging in commercial transactions by coming into the state, right? What's more, they say, as the petitioners point out, 95% are from out of state or out of country, which requires transportation across state lines of the campers. The campers are the commerce, right? The campers are comparable to hotel patrons and other goods and service users. Then they cite Heart of Atlanta, right? People can be the instrumentalities. And they say that the town also tried to claim that because real estate is at issue, that the Dormant Commerce Clause doesn't apply. But the court says no. A tax on real estate, like any other tax, can burden interstate commerce. Think about substantial effects tests, right? Okay, that doesn't work. Let's go on to number 2. You don't like that claim? We got another one. Next, we have to ask if precedent prevents the states from imposing a higher tax on entities that serve non-state residents, right? So, yeah. So what main law here, they say in this bit, is clearly, in point 2a, is clearly distinguishes between entities that serve interstate clientele and those that work within the state. This has the effect of encouraging businesses to limit their clientele to avoid out-of-state clients, doesn't it? Because I can get this tax break if I don't serve non-Mainers, I guess they're called, right? And they say the court has consistently held that the Commerce Clause precludes a state from mandating residents be given a preferred right to access over out-of-state citizens. And they cite a case called New England Power Company versus New Hampshire. So they say, of course, this isn't a ban, but it's still an incentive. And that doesn't avoid the fact that the tax scheme is facially discriminatory. It still has the same, quote, pernicious effect on interstate commerce. It doesn't matter that it's a tax. It's the burden that matters, right? Okay, moving on. 3. Should there be a for-profit or not-for-profit distinction? Right, benevolent not-for-profits. So does it matter for the purposes of the Commerce Clause that this tax only applied to not-for-profits, or does it matter that it only looks at businesses that are out for profit? The court's going to say no. They say there's no reason why nonprofits should be immune from negative Commerce Clause analysis, and they say that the town of Harrison doesn't argue for this. Rather than suggesting that the court create a categorical exception, the town argues that Maine's exemption should be viewed as a government expenditure meant to lessen the social service burden and foster these societal benefits. I'm on the wrong slide. Damn it. Let me get over there. There we go. We're in 3. Okay, moving on. We got 2 more claims. So we shot those down. Let's go on to, I think this is, let me see. First. Oh, there it is. This is number, I guess this is technically, it's number 3, but I guess this is technically claim number 1, 2. This is technically number 3 on point number 4, their third claim, I think. So they say, Town of Harrison says that since discriminatory subsidies are okay, it also must be the case for discriminatory exemptions, meaning tax exemptions that the camps get, right? The court says no, right? They reject this type of analysis. And they cite 2 cases. They say the first one is Walz, W-A-L-Z, versus Tax Commission for City of New York from 1970, which held that a New York tax exemption did not violate the Establishment Clause, and this holding rested on the conclusion that there was a constitutionally significant difference between subsidies and tax exemptions. And then they cited a second case, New Energy Company of Indiana versus Limbach in 1988, and there the court found unconstitutional, for Commerce Clause reasons, an Ohio tax scheme that provided a sales tax credit for ethanol produced in the state or made in another state that provided that the other state gave similar tax benefits. And they said this was because the law had a discriminatory effect on out-of-state producers and competitors of ethanol. And so what they say here is the purpose of these cases is that while the Commerce Clause doesn't ban state actions to give residents an advantage in the marketplace, it prevents discriminatory taxation of the interstate marketplace, but allows direct subsidization of a domestic industry. So you can try and prop up an industry by giving them money, but when you're talking about taxation, they're treated sort of differently for Dormant Commerce Clause analysis. Last claim. We've lost on all the other ones. Point number 5. Well, what if we're just a market participant, right? We're a market participant. We should be allowed, right? Court says no. Tax exemptions cannot be considered a market participant activity. That's just stupid, right? There's no way, if you're a market participant, like you're a seller of a good, there's no way you could levy a tax at all. So that's just completely silly. Scalia has a dissent. This is, I believe, a 5-4. Thomas also has a dissent that we read. So he says the court here treats this case like it's facial discrimination against interstate commerce. And laws that are protectionist in purpose or effect are therefore invalid, right? If they are, then, as it says here, the virtually per se rule of invalidity would apply. But laws that are neither discriminatory nor protectionist may still be reviewed, possibly struck down, possibly not. This is the idea of Pike balancing, right? He says the court determines that via the residual balancing test that this balancing originates from Pike versus Bruce Church, 1970. That, remember, if you remember that case, was about Arizona requiring Arizona-grown cantaloupes to advertise their state of origin and on yada yada. So they reasoned in Pike that an even-handed regulation for legitimate local interest where the burdens are incidental, right, small, localized, are okay, but if the burden is excessive in relation to the local benefit, then it's not okay, right? That would be sort of the idea of per se rule of invalidity. So he starts off by saying that the negative or dormant commerce clause has drifted far from its purpose in creating national markets. He says here he begins with the idea that either it's invalid virtually per se rule of invalidity, or it's going to be a balancing test. Where the balancing test is the law will be sustained unless the burden imposed on interstate commerce is excessive, right? So he's just reiterating the standard, right? So let's look at it here, right? So in Hughes versus Oklahoma, we created an exception to the virtually per se rule of invalidity. And remember, we just read that one a second ago. And Scalia argues that even though the law may be facially discriminatory in this case, that doesn't necessarily mean that it's invalid. So basically he's saying this might fit under the exception carved out in Hughes. What may appear to be discriminatory provisions in the constitutional sense, like protectionism, might actually not be. And then he cites in point B here, when would this occur? He cites New Energy Company of Indiana versus Limbach in 1988 to say that even if statutes erect an absolute barrier to the movement of goods across the state lines, that it should be upheld if the discrimination is justified by a valid state factor unrelated to economic protectionism. So what is the legitimate state interest here? It's basically just that they're trying to prop up their businesses and support those that service their citizens, right? He says that, and then he sort of criticizes the majority here. He says the Commerce Clause doesn't prohibit all state actions designed to give residents an advantage in the marketplace. It only actions connected where the state is trying to regulate the interstate commerce. At issue here, he says, is the tax exemption. The Maine law, he says, is only in violation if it facially discriminates against interstate commerce. But here the parties in question are not similarly situated. The state distinction is between citizens and non-citizens. And he says, even if it were facially discriminatory, which is his last point, point number 3, even if it were facially discriminatory, that is not the end of the analysis. Basically saying that the majority, stopped too soon yes, maybe it is facially discriminatory, but that's when Hughes would kick in. We'd ask, is there a legitimate government purpose, right? So he says, even if we proceed with further analysis, we could find the virtually per se rule of invalidity in his mind does not apply. This is not economic protectionism, at least no more than any state law that dispenses public assistance only to its own citizens. So he says you should have taken this to the next step, which is Hughes. You stopped too soon. Thomas, of course, is going to have a rather radical opinion. He says he has basically expressed doubts about the Dormant Commerce Clause at all. He says the negative Commerce Clause was meant to invalidate state tax schemes that tax interstate commerce, but it has grown too broad. He said it's unnecessary. It's also unnecessary because the Constitution provides in Article 1, Section 10, Clause 2, there's a clause that's called the Import-Export Clause. It says that Congress can regulate the import and export of goods, internationally. And this was meant to prevent discriminatory taxes of other states. The weird thing about this, though, is nobody else on the court, to my knowledge, has ever read the Import-Export Clause that way. Thomas is really the only one. Traditionally, this clause has only been applied because it's import-export. This clause is, by most people, been understood to apply to international trade and not interstate trade, right? Because it would seem kind of odd that you would have both of them. You would have an import-export clause and a commerce clause if they both applied to states. Because then all you would need is the Commerce Clause. You wouldn't need the Import-Export Clause or just the Import-Export Clause, right? So it's a very weird interpretation. And so secondly, he goes on to say that he rejects the claim that Congress has exclusive reign over the Commerce Clause because in the past, way past, like 1800s, 1700s, the court has rejected that the Commerce Clause forecloses any sort of state action. So he says that when Congress is silent, I'm sorry, let me rephrase that. Actually, this is worded a little bit oddly. I should change the language here. There we go, I fixed it. So it should read, congressional silence is not equal to preemption of state legislation. He rejects that the silence equals preemption argument. In other words, that because the court, he says, determines not just if there is preemption of the state laws by the federal government, but if there was, one, a state law in direct conflict, and two, if Congress has truly preempted it via some sort of legislative field. So he's sort of saying, like, look, we shouldn't necessarily assume that Congress has this authority without exercising it. Again, a very odd way of interpreting the Commerce Clause, but there you go. Okay, Granholm versus Heald. So this is going to get into some of the weird areas of commerce. Wait, do we have this one? No, okay. We got two more cases. Granholm case, which is going to deal with sort of the wonkiness of the 21st Amendment because it sort of adds a layer of confusion to the Commerce Clause because it gives states the ability to sell alcohol in their borders and basically they can discriminate against it. It sort of carves out a weird exception. And then we'll look at Comptroller of the Treasury, which is going to look at Treasury of Maryland, which is going to look at tax credits and whether or not those can violate the Dormant Commerce Clause. So let's start with Granholm versus Heald. So this case addresses the directly addresses the negative Commerce Clause. The facts here in Michigan, they said that most wine producers had to go through wholesalers except in-state wine sellers, in-state wineries, which could get their winemaker license that allowed them direct shipment to in-state consumers, right? New York also made, so there's actually two sort of laws at issue here. New York also made exceptions for in-state wineries in that local wineries made direct sales to consumers on more favorable terms, but out-of-state wine sellers could only be shipped directly to consumers if they became a New York licensed winery, requiring both a branch factory office or a storeroom. So basically, they're putting physical. You can get favorable rates, but only if you put your business, or at least some element of your business, within our state borders. That's basically the crux of this, right? So can they do that? Or is this a violation of the Dormant Commerce Clause? Here they say it is. Both of these laws are in violation of the Dormant Commerce Clause and the 21st Amendment. Even though it has language here that gives states a lot of power, it's still not permissible, right? It's not just a free-for-all. This house also, by the way, had a weird ideological split. It had Stevens, who is kind of a moderate left-leaner, Ginsburg, far left, Souter, it had Ginsburg, Souter, Breyer, who are all kind of left-leaning, but it also had Kennedy, the swing vote. It also had Scalia, who is a conservative, and then in the dissents were Stevens, who's sort of left-leaning, O'Connor, a centrist, Rehnquist, far right, and Thomas, far right. So you had a weird sort of ideological split on the court in this 5-4, but made it for sort of interesting reading. So let's go to the majority opinion by Kennedy. So the first thing they take up is this differential treatment, right? Both New York and Michigan's laws discriminate on out-of-state producers versus in-state producers. So why is differential treatment a problem? They say it's a problem because it deprives citizens of the right to have access to markets in different states, and those markets should be accessed on equal terms. We end up instead with a, quote, patchwork of laws, with some states totally banning direct shipments while other states only do so for out-of-state wineries. So they say, and then they go over what these discriminatory schemes are for Michigan and for New York. So what Michigan and New York try to claim is that if you look at the 21st Amendment, the one that repealed prohibition, let's pull that up real quick. Let me pull it up. Okay, we got 3 sections. First one, it directly says 18th Amendment is repealed. 18th was the one establishing prohibition. Section 2, which is important for our purposes, transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. So this is the thing that gives us a little bit of confusion and issues with Commerce Clause analysis, because it says it gives the states then, in violation of laws thereof, right, states or the territories, they then can totally regulate the importation and export of alcohol, right, or importation of alcohol. So this means that they have total control, meaning they could ban it entirely if they want to. In some states they do that, like in Arkansas, right? I believe all of their counties are dry. Or no, wait, I'm sorry. Some of them are dry, some of them are wet. That's what it is. So, like, it just varies, right? And some states have done that. They've left it up to the counties. In Texas, there are a few of these as well. There's only like a handful. Most of them abide by the same laws, but they don't have, it's up to the state how they want to deal with that. Then finally, Section 3 is just about ratification. So, the key issue that we're concerned with is Section 2, allowing the states to police these policies. So what New York and Michigan are saying here is that, look, Section 2, the issue is, well, can that allow them then to engage in this discriminatory practice? And the court's going to say no. They say the court argues that it doesn't allow states to regulate direct shipment of wine on terms that discriminate in favor of in-state producers. And the reason why they say this is the 21st Amendment, according to them, did not give states the authority to pass non-uniform laws in order to discriminate against out-of-state goods. And they go through the history of this, right? So they look at a number of cases before the 18th Amendment was passed, before Prohibition went into effect. The court relied on the Commerce Clause to invalidate a number of state regulations. Because the Commerce Clause prevents states from discriminating against imports, because the Commerce Clause prevents states from passing facially neutral laws that still burden interstate commerce. So while this shouldn't be that surprising, perhaps, the idea of virtually per se rule of invalidity has really been around since 1870s in a case called Welton versus Missouri in 1876. And in that instance, I think the quote, this is the quote I think from that case, they said, quote, "The non-existence by Congress of its power to regulate commerce amongst the several states is equivalent to a declaration by that body that such commerce shall be free from any restrictions." So this is a really old idea. It's just given it maybe a new polish by calling it the virtually per se rule of invalidity. From there, the court cites examples such as Bowman versus Chicago Northwestern Railway Company from 1888, where the court struck down an Iowa law that required alcohol importers to have a state permit. What Bowman didn't answer, though, was if a state could ban all imported liquor. Iowa made a law that effectively just did that in the 1890s, or late 1880s or early 90s. Iowa, so they banned all of it, all import. The court struck that down, though, in the case called Leisy, I think, Leisy versus Hardin in 1890. So we know that they couldn't do that. So we can look to those cases and then see, give us some guidance as to how the court should handle it, given, now that the 21st is around. Congress also has weighed in here. They passed the Wilson Act, and this gave states permission to regulate the imports of alcohol to the same extent as domestic or in-state liquor. But in Vance versus V.A. Vandercook Company in 1898 and Rhodes versus Iowa, also in 1898, the court said that the Wilson Act can't regulate importation for personal use. So what did Congress do, right? This is, again, going through this long historical chain. So when Congress was kicked in the face for the Wilson Act, they went to the drawing board and they passed the Webb-Kenyon Act of 1913. And this allowed bans for personal use as well, so long as in-state and out-of-state liquor was treated the same. That's the problem, right? The legislation here is not satisfying that exception, right? Michigan and New York are trying to rely on the Webb-Kenyon Act of 1913. But the court said that doesn't work, and here's why. Firstly, we had a ruling that came after Webb-Kenyon called Clark Distilling, and it ruled that the Webb-Kenyon extended the Wilson Act to incorporate alcohol shipment to intercept alcohol shipments before the shipments reached the recipient. And the Webb-Kenyon Act didn't repeal the Wilson Act, which excluded states from discriminating against shipments in-state and out-of-state liquors had to be treated equally under both of these, right? So that argument, sort of doesn't work. And so what do we take away from this? What they said is that in all but the narrowest of circumstances, state laws violate the Commerce Clause if they mandate differential treatment for in-state versus out-of-state and benefits in-state but harms out-of-state goods. So, yeah, so that's pretty much it. There was also a few minor claims. One was that they tried to say the 21st Amendment, Section 2, said that we can create non-uniform laws, but they said no, we've already had a case called Bacchus Imports versus Dias, and they said that dealing with an excise tax, and they said no, that doesn't work. Then they also tried to make one minor claim saying that, well, look, if we don't, minors could buy it over the internet, and that's why we need the regulation. But there's no evidence, there's no evidence that was happening, so that doesn't really work as an argument. Yeah. So Stevens has a dissent. Thomas has a dissent. I think it's just... Okay, so yeah, Thomas has 3 points. Stevens has these 2. He says that the New York and Michigan laws would be invalid under Dormant Commerce Clause if they regulated something other than wine. But because of the 21st Amendment, this is weird, right? He says that since we've adopted the 21st Amendment, it has been placed in this sort of special category. And he says Section 1, of course, repeals. Section 2 gave the states the option to maintain equally comprehensive prohibitions within their jurisdiction. We just read it, right? So, he says, sort of ipso facto, since New York and Michigan laws regulate the transportation and importation of alcohol for delivery or use in the state, they're exempted from the Dormant Commerce Clause. He says it shouldn't apply, that the 21st creates this unique situation. Thomas has a rather lengthy dissent that's not really very interesting. I'm not really going to go through it for the sake of time. Let me just see if there's maybe one point we can take away. I'll just leave it to you, but he just goes through sort of a historical review of the Wilson Act and the Webb-Kenyon Act, and he doesn't think their historical analysis was correct, but I'm not really... It's kind of boring. I'm just going to skip it. Okay. Our final Dormant Commerce Clause case before we move into the Contract Clause. So... Here, this is about pass-through income. This refers to, well, let me give you just what happened, and it'll explain what we mean by pass-through income. So Brian Wynne and his wife are Howard County, Maryland residents, and they own stock in Maxim Healthcare Services Incorporated, Maxim for short. And this company provides healthcare services nationally. So the Wynnes claimed the share of the Maxim income in taxes that they were paid as credit against their Maryland income tax, which includes the Maryland state taxes and Howard County taxes, the county in which they reside. The Comptroller of Maryland, however, determined that the Wynnes had incorrectly calculated their county tax debt by including the taxes they had paid to other states and issued an assessment saying you still owe this tax. So basically, what they're trying to do is say, look, we had to pay this tax because of this pass-through income, the stock we own, right? And therefore, we're going to claim that as an expenditure on our state income, and therefore we should pay less in state. Right. So the question here is, without this credit, then, this means that out-of-state income is taxed twice, right, by the state and then by Maryland, right? I'm sorry, by this, by out-of-state, by whatever, by other states, and then also by Maryland. So you effectively could get taxed twice. So the question here is, did this Maryland scheme violate the Commerce Clause, particularly the Dormant Commerce Clause? And they're going to say, yeah, it did violate. It is a violation of the Commerce Clause. So, let's start with Alito's majority opinion and work our way through this. He starts us off by saying, take a look at this quote, Maryland's tax scheme creates an incentive for taxpayers to opt for intrastate rather than interstate economic activity. You're incentivizing people to not spend their money outside of Maryland for fear that you're going to have to pay taxes on it out of state, right? He says, without the credit, this means that out-of-state businesses... sorry, I already said that. Well, he says here, being effectively taxed twice, is this a problem? He says, while there has been some dispute, and he says, you can see the dissent for this, that this says that this, in my mind, this matter is settled. In J.D. Adams, a case they took up in 1938, the court struck down an Indiana law that taxed money earned out of state, and the court held that this was a violation of the Dormant Commerce Clause. And a similar result was reached a year later in a case called Gwynne. It's listed here, right? So there's J.D. Adams, there's Gwynne. And finally, in this Central Greyhound Lines case, New York tried to tax gross receipts derived from services to neighboring states. All three of these cases resulted in essentially double taxation of income, right? Earned at, because you have to pay the out-of-state, earned you out-of-state, and then can be paid in-state, which meant preferring intrastate commerce. And they said, we have long held that, this process, and they also cite some of the Federalist Papers that you can see here, they've long held that states cannot try and discriminate against interstate commercial activity. By Maryland failing to offer the same tax credit to income earned out of state, you're now incentivizing people to never want to earn out of state income. And they see that's discriminatory. That's creating a discriminatory effect upon the interstate marketplace, right? And then the rest of the opinion, as it says here, concerns this, right? It spends the rest of the opinion consulting the dissent and why they were wrong. So the principal dissent, he refers to the principal dissent like the main dissenter, but there's multiple dissenters. So I think he's referring to Ginsburg. It's not 100% clear, but I think it is. He doesn't actually say. Point A, gross receipts versus net income. Alito says he sees no reason to make this distinction between the gross receipts that you've earned and the total income that you've earned. He says that the court used to do that, but in a case called Western Livestock versus Bureau of Revenue in 1938, the court replaced this with a direct versus indirect burden test, one that looked at the economic impact. So we don't really care about where the income is coming from, rather the effect on your income. Secondly, on point B, taxing a corporation versus individuals, he says we've also rejected this idea that there's any distinction. He says that corporations also benefit from state and local services. It doesn't matter that they can't vote or do other things that people can't do, that people can do, right? They're not citizens. They can still influence state lawmakers. So it doesn't matter that it's affecting corporations or individuals, right? And finally, the ability of states to double tax. To allow this double taxation would be a sea change, he says, from Commerce Clause jurisdiction, right? From there, he then transitions into, he addresses Scalia and Thomas's dissent by name. So on Scalia's dissent, he says that, where is it? Oh, yeah. So what Scalia tries to claim is that, look, the Constitution addresses the problems of tariffs, treating in-state, out-of-state stuff via the imports, tariffs on imports or duties, or tariffs or duties, whatever, on via the imports-exports clause. We mentioned this before. This is in Article 1, Section 10, Clause 2, right? For Alito, though, writing for the majority, he says, I don't understand why, even if we relied on that clause, that this wouldn't lead to the exact same result anyway. So just saying, this could actually be resolved by that clause, which deals with things like international trade, potentially interstate trade. Why wouldn't, that doesn't really resolve the problem of Commerce Clause, right? And then finally, he addresses Thomas's dissent. And Alito offers 3 points why Thomas is wrong. He says, one, not many people used interstate travel in 1787. So you can't really use those ancient sort of, foundational documents to say that, look, this is really, how taxation should work between states. Two, there doesn't appear to be any double taxation schemes at the founding that existed at all, so you can't really look to evidence there. And thirdly, even if some were taxed twice, it didn't seem to be common knowledge to the delegates, right? This idea seems totally new, not something that the founders envisioned. With that, we'll turn to Scalia's actual dissent. So what did Scalia actually say? He says, as evidence, he looks to the, quote, at the illogical holding that that congressional consent enables states to enact laws that would otherwise constitute impermissible burdens on interstate commerce. This seems like a kind of a misinterpretation to me, but he's saying Congress has the sole authority, so they technically could cede away their authority, but okay, maybe he's doing it for sort of alliterative effect. So, moreover, he says that he notes that the years after the adoption of the Constitution, states made burdensome regulations like pilotage laws and quarantine laws, and those things existed, right? And that didn't seem to be a problem. We're not going to do, where am I at? There we are. We're not going to do Thomas's dissent because it's kind of boring. I did want to mention one word for Ginsburg, though, just this one point here, and that is that there's nothing in the Constitution against double taxation. It doesn't exist, right? There's no language in there that doesn't allow that. And she said, quote, a nation or state may tax all income of its residents, even income earned outside the state. And she cites Oklahoma Tax Commission versus Chickasaw Nation from 1995. And that is that, just, the power, there's nothing in there, but there's a power about taxation, but there's nothing in there about double taxation. So we shouldn't infer that there's a ban against double taxation. It's as cruel as it may seem. Okay. All right, I need to change my slides. We're going over to the contract clause. So we've only got a few topics left. We've got the contract clause, which we're only going to do a few cases on. There's not many of these cases in modern times anyway. We're going to take up the We're going to look at economic due process and the due process clauses. So also, if you're going to take Common Law 2 in the fall, which hopefully will be in person by then, you'll definitely want to pay close attention to those because that's going to be really a big focus, the due process clause of that class. In fact, it's really, well, that and the equal protection clause are going to take a big chunk of the time. And what was the other thing? Oh, the takings clause. The takings clause in the Fifth Amendment. It's also called eminent domain, taking property for public use with just compensation. Sometimes you'll see that if you ever go to like law school, I think they skip over that topic, or maybe no, I think maybe they do it. I don't remember. It might fall under its own class in property rights, or property law, but yeah, I like to put it in here. It's kind of odd. It's one of the few cases we look at where we're actually looking at one of the Bill of Rights provisions. But since it involves the interactions of states and federal governments, citizens and state governments, I think it makes a little more sense to put it in this class. Okay, contract clause, Article 1, Section 10, Clause 1. No state shall blah, 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 all the things the states cannot do. One of the things they cannot do is they cannot pass any blah, 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 or law impairing the obligation of contracts. So states can, this is one of the restrictions on state powers, states cannot infringe contracts, private contracts between individuals enter into these contracts in good faith. So let's look at Dartmouth. Dartmouth, of course, is a college. Background of the case, Britain chartered Dartmouth as a university back in 1769, super old. In fact, one of the oldest in the nation. And, however, we have a Revolutionary War. After the Revolutionary War, New Hampshire wants to bring the college under state control, not private control, right, to run it by itself. So they, the College Board of Trustees says you can't do that, right? We have our original charter here. It's still good. We had a contract. You cannot void our contract. The question is this. Did New Hampshire violate their contract, even though it was made with another country, right, that no longer occupies sovereignty in this country? Did they violate it? Yeah, they did. That the government here may not infringe on private contracts, even if those parties, one of them was, the British Crown. So, how do we get there? So, New Hampshire, it says here, tries to argue that if the court gives contracts great latitude, then all types of contracts may interfere with the internal concerns of the state. In other words, if you take this too far, then you're going to disrupt the ability of the states to do their job. Woodward claims that, as I said, that if the contract's upheld, we'll see all sorts of contracts burden the workings of the state. The court replies by saying this: no, that contracts were meant to guard against power. Right, that's one of the purposes, to prevent state legislatures, as it says here, from violating property rights. To do this, the Constitution prevents the state legislatures from passing any law that would impair these obligations. It's meant to be an individual privilege. It's a guarantee that the government will not take away this right. So, what about this then? You don't like that argument? How about, is the school a corporation, or is it merely an extension of the government? So maybe you could simply say that, well, it's a school. It's not a private party, right? So we're not violating the contract rights of an individual. We're violating them of the school, and school's not a person, right? But they say, well, no, this is a corporation, right? The first they define it, an artificial being, invisible, intangible, existing only in the contemplation of law, and it is immortal, meaning the owner of the business, that if one person dies, it doesn't mean that the business goes away, right? It continues on. So they say, even though corporations can transfer control, right? You can be sold, bought, that the charter of incorporation doesn't change the institution, and it doesn't transfer control over the government. That incorporating act neither gives or prevents government control. The incorporating act didn't change the character of the institution. It didn't transfer it to the government. So for the purposes of law, we're treating corporations like individuals, but they're clearly not. But for purposes of the contract clause, they will be treated like individuals, like an individual contract. Finally, last slide here. Marshall's opinion continued. So he says the conclusion must be contractual obligations cannot be impaired. So has New Hampshire impaired here, right? What prohibits? We know that they're infringing on contracts is a violation. Is there a violation here? The Constitution, they say, limits the state's ability to impair these contracts. Here, the actions of New Hampshire via Woodward weren't those of the corporation or the controlled party. Therefore, they are repugnant to the Constitution. This may not take place. So let me give you a little aftermath of this. After cases like this, there weren't that many of them. We saw many states try and get around this problem by passing a slurry of retroactive insolvency laws. Retroactive insolvency means that if a business later becomes insolvent, meaning they no longer can sustain themselves, that the contract that the business would revert to the state, or the contract would be considered nullified. And so they would include these provisions that allowed them to. And so in 1827, the court, in a case called Ogden versus Saunders, said that those laws could validly be applied to contracts that were made after the law was enacted. In that case, it dealt with a New York bankruptcy that was made after the contract was considered not invalid. And so the consequence of this is that we, what was I going to say? Oh yeah, we don't really see many of these cases, because now states can simply get around it by creating these retroactive insolvency laws. So there's not many contract clause cases. We will look at a few of them, though. States could, therefore, make laws that were considered to be reasonable remedies. For example, in Bronson versus Kinsey in 1943, the court said that permissible remedial changes depended on the scope and reasonableness, provided that there was no substantial right impairment. So in other words, states, it doesn't mean that they also can't modify things that would have an effect on the existing contract. So like, for example, what if I want to make could I sell you a child? Well, if I could make something illegal and therefore prevent the contract from being created in the first place, what if you had a contract that gave you ownership to a child, or like a slave or something like that? That doesn't mean that it wouldn't run up against other constitutional challenges, right? Additionally, in the late 19th century, we saw the rise of substantive due process claims, which we'll look at a little bit later, to restrain economic regulation, and this kind of usurped the contract clause. And until really the 1970s, it was often assumed that the contract clause and the due process clause were effectively the same thing, and they had merged. But we'll see that no, they're clearly distinct. It just doesn't come up very often. Okay, let's turn to our second case. I wonder if I can find a picture of this. Hang on one second. There we go. I guess it probably was this, or maybe this one. Charleston. Yeah. Well, either way. So, you can see where the bridge was supposed to go. So, this is very nice. I'm glad I found this. So there it is. So there's the old Charles. I just Googled Charles River Bridge Company, and this is the images that came up. So yeah, you can see there's the old bridge, and then there's the new bridge, right? So as it says on the slide, Massachusetts gave the Charles River Bridge Company exclusive rights to build a bridge from Charleston to Boston. However, many years later, 1828, the Massachusetts took control of the Warren River Bridge Company and allowed it to build another bridge across the same river. What river is this anyway? I don't know. Whatever. It doesn't matter. And so the company said, well, wait a minute. We had this bridge. We were charging tolls. If you build another bridge and it's not going to charge tolls, because the new government bridge would not charge a toll, you're going to bankrupt us. So the question is, did you violate that original contract by granting them the monopoly rights to build that bridge, by then later granting another business the ability to build a different bridge that doesn't charge tolls? The court says no, right? The contract said, yes, you have a monopoly to build this bridge, right? Didn't say all bridges, and it didn't say that there wouldn't be future bridges. It's ambiguous. It's not clear. So they say that when there's ambiguity, it must work against the adventurers and in favor of the public, right? So let's go through our ruling before we wrap up. Good, we're ahead of schedule. So they say here that when, quote, ambiguity works in favor of the public, and they go on to say that in this first point here that that the taxing power, like the taxing power, the whole community has an interest in preserving the undiminished power of the state. Government would have little value if it was disarmed of the powers it needed to accomplish the ends of creation, the functions it was designed to perform, transferred to the hands of privileged corporations, right? The public, in other words, should not suffer because of, the greed of one company. And he goes on to say that, quote, while the rights of private property are sacredly guarded, we must not forget that the community also has rights. So was this grant to build the original bridge to Charles River Bridge Company a monopoly that meant that they could never build another bridge? They say, while the Charles River Bridge Company was given the ability to build the bridge and collect tolls, it wasn't given an exclusive right to build any bridges in the remainder in perpetuity across this river. Nor was it the ability to maintain the monopoly. Nor does it deny that the state the right to allow another bridge to be built. The original contract is silent on this, and so we can't infer what it would mean, right? What about the fact that you're going to bankrupt me? You've created my franchise. You make my franchise worthless, right? They complain that their income is destroyed without if they create this. If the Warren River Bridge Company creates this new bridge, right? And therefore, you're going to injure us. The court says, in response, in point 3a here, that, quote, there is none, no words that even related to another, there are none, no words that even relate to another bridge or to the diminution in their tolls or the lines of travel. So the question becomes, even though it wasn't mentioned in the original contract, should it be implied or inferred? And the answer is no, right? Quote, no rights are taken from the public or given to the corporation other than those listed in the charter. And if we look historically, quote, these corporations have in some instances been utterly ruined by the introduction of newer and better modes of transportation. Yet in none of those cases did we assume the corporations have privileges to or claim that their contract were violated. In other words, you could think about this in all sorts of situations too. Like, what if, okay, I'm going to build this new road, and then I'm charged tolls, and now everyone switches to flying cars. You can't, that's it. The risk goes with the risk taker, right? Not with the state. So finally, point 4, the state interest is clear, they say. The state has the authority over its own internal workings. One of the sort of weird problems here is Tawny is saying that the majority is always right since the new bridge serves the greater good at the expense of this one minority business, right? But was this really the purpose of the contract clause? It seems like a little bit further than he perhaps needed to go. All right, last slide for the day. I think, let me double check. Yeah. Justice Story's dissent. So he says in his first point here that there is an implied agreement from the state to the company not to destroy the use of the bridge or the tolls, and he cites history for this, saying that there's nothing under the British Crown nor in our short history, nor in history that seems to justify this ruling. Destruction of this franchise. And then finally he concludes with saying, common law suggests that there is no more right to build this new bridge and there's to transfer authority of the bridge from one company to another. This is sort of like a takings clause thing. So like, what if I said, okay, well, I'm going to take this property with compensation for public use. I'm going to give it to that guy, right? He's saying this is essentially is tantamount to that, right? Maryland, he says, is an impairing on the obligation of the prior contract and a prior grant. Well, that's a little iffy, because allowing somebody to do something else is not the same as a transfer, right? They're not even remotely close. Okay, that's it. We're done. We're going to pick up next week with the contract clause, and then we're going to do a hard 180 and look at due process. Slaughterhouse cases is super fun. Lochner super important. And then we'll look at sort of economic and substantive due process a little bit there. And then after that, we will, beginning with the same week, so next week, we'll begin the Fifth Amendment Takings Clause stuff with Hawaii Housing Authority versus Midkiff and Kelo versus City of New London. So those last two cases, let me just pull it up. I don't know why I'm rambling to you. There we go. There. So these last two here are going to be takings. We're going to start the Takings Clause. These guys are going to be... these guys are going to be looking at due process, and these are going to be more contract stuff, contract clause case. Okay, that's it. Let's see everyone next week.